In the wake of the search warrant at Donald Trump's Mar-a-Lago home, there's been a lot of discussion about the level of classification of the documents retrieved. Top secret, some higher than top secret, but many of them clearly marked as classified. And putting aside whether it even matters legally, whether the documents were technically classified, and it may not, it certainly matters to most of us who are following the story. Now, the president has broad powers to declassify documents. But what does that mean? Does he have to do anything specific? Does he need to tell anyone? We're going to have a straight fact-based analysis from a national security expert from the Bush administration in a moment. Now, the former president claims he issued a standing order directing that any documents that left the White House be immediately deemed declassified. In other words, all those boxes of documents, simply by leaving 1600 Pennsylvania Avenue for Mar-a-Lago, shed any special status, or so the argument goes. The FBI used a warrant to seize, among other things, 27 boxes from Trump's Florida residence. In those boxes, 5 sets of documents marked as top secret, 3 sets initially classified as secret, another 3 that were confidential. In all, the FBI receipt indicated that 11 were classified. Now, all of this began in January, when Trump sent, upon request, 15 boxes of presidential records to the National Archives and Records Administration. A month later, the archives reports documents in those boxes were classified. But clearly some of the documents they'd been looking for weren't there. By spring, the FBI had a subpoena, went to Mar-a-Lago for a first time. They clearly believed there were additional documents, and then in June, yet another visit, this time including the FBI's chief of counterintelligence, Jay Bratt. Clearly unsatisfied with what they were receiving and being told, on August 8th, agents executed a search warrant. Now, past presidents have typically directed subordinates to declassify certain documents, a process more systematic and regulated than a change of address. President Barack Obama, through an executive order, established a national declassification center to make more documents public faster. He appointed the archivist of the United States to lead and streamline that effort. And it is clear that whatever one thinks about the classification status of the documents, that Trump clearly did not follow the regular procedures. But that doesn't necessarily mean that he didn't technically declassify them. A former lawyer for the National Archives told the New York Times that Trump's argument and failure to log any of the alleged declassified records is preposterous. And there is an argument that if you don't tell the other agencies that the documents are no longer classified, that they would continue to treat them as such, and it would defeat the purpose. But even if it's abnormal or unorthodox or even negligent, does that make it invalid? Does that mean the documents are still technically classified, or does Trump have a real argument that if he says he declassified them as president, then they are declassified? Jamil Jaffer is a former associate White House counsel in the George W. Bush administration and founder of the National Security Institute. Jamil, thanks for coming on the show. Appreciate it. All right, so let me ask you the ultimate question. Is a president required to follow any kind of process to declassify documents?
Well, you know, Dan, it's a complicated question, but I think the basic answer is no, not as a former rule matter. The general classification and declassification of documents is governed by an executive order that's been updated by various presidents, including President Obama. And it provides that the president has original classification authority, and as a supervisor of people who have original classification authority and as original classifier himself, has the ability to declassify at least the documents that he's originally classified, if not documents originally classified by others.
And even if he doesn't tell anyone else. So he can say, I had a standing order that literally any time I touched a document outside of the White House, it was immediately declassified, and that may be good enough.
Well, you know, that's a little tougher because, one, a standing order would need to be, you know, sort of accomplished somehow. So you have to have told something about that standing order and have a standing order. You can't simply...
Do you?
Well, you can't simply think it in your head and it be so, right? A standing order implies that you're directing somebody to do something. So, you know, the president had to have embodied that in some way, told somebody, said something for it to be a standing order, right? I think just by even just the colloquial use of that term, right? But, you know, the separate question of whether he declassified these documents, you know, before he left the White House, you know, he may have very well determined they were declassified. Presumably, in order to evidence that in a court, if he was going to try to make that argument, he'd have to demonstrate something other than his own testimony, right? He'd have to say, okay, I did this. Okay, well, Did you take any steps to demonstrate that? Did you make them public? Did you tell somebody you declassified them? Did you mark them as such? If he didn't do any of those things, right, a court would have to take his word against the word of others, and the default assumption under the executive order, which is that documents that continue to meet the requirements for classification generally remain classified, which is what the EO says.
Does it matter, do you think, if they were classified or not as a legal matter?
Well, there are a few different statutes that might play in here. One is the executive order and statutes implementing the executive order that say if you retain classified materials and are asked to turn them over, don't return them, you could be violating the Espionage Act. That's one provision.
But but that wasn't one of the three in the search warrant.
Well, so Espionage Act was cited, and there's a provision of the Espionage Act.
Yeah, right.
Right. And there's a provision there that says if you're asked, if you know that a document is classified, right, and you are asked to return it, and you don't do that, you can violate the Espionage Act.
It doesn't refer to classified, right? It says national defense material. My point, I'm not trying to get in pedantic with you, but this does matter. I mean, there is nothing in the three statutes that specifically says, oh, it has to be quote unquote classified. But I think to the public, it matters, right? I mean, if these were incredibly sensitive, highly classified documents, it matters more than if they weren't, right?
No, you're exactly right. One, is a public matter, it matters a lot more. But two, you're right that as a general matter, the statute talks about national defense information. There's often, sort of a one-to-one relationship between NDI, not always, you're right to point that out, and classified material, typically material classified at the secret or top secret level. But you're right, the statute refers to national defense information, not specifically classified material. That's
This is the problem with two lawyers sitting here and talking. We've now, the answer to the question I started this with, which is, does the president need to have done anything else? The answer is, well, kinda, but it's not exactly clear what he needs to have done. And look, this is the way the law, particularly when you're talking about an executive order, which isn't even codified in law, exists. Jamil Jaffer, thank you for the straight talk.
Thanks, Dan.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.